Yeah, sounds like it's true.
Order.
The Draft Employment Rights Act 2025 Investigatory Powers, Consequential Amendments, Regulations 2026.
I call the Minister to move the motion.
Thank you, Mr. Stewart. It's a pleasure to serve under your chairmanship. I beg to move that the committee has considered the Draft Employment Rights Act 2025 Investigatory Powers, Consequential Amendments, Regulations 2026. These regulations are narrow, necessary and strictly consequential. When Parliament passed the Employment Rights Act last year, it took the clear policy decision to bring the criminal enforcement functions of the Gangmasters and Labour Abuse Authority into the new Fair Work Agency. Those functions include the ability for the GLAA, as provided for in Schedule 4 of the Investigatory Powers Act, to obtain authorisations to acquire communications data in the most serious cases of labour exploitation. The sole purpose of this instrument is to ensure that capability continues seamlessly when the Fair Work Agency becomes operational in April. It updates the statutory reference that currently names the GLAA so that the same powers are available to the new agency when carrying out the serious exploitation investigations previously undertaken by the GLAA. So let me be clear about what these regulations do not do. They do not create new investigatory powers. They do not widen the scope of existing powers under the Investigatory Powers Act. And they do not lower statutory thresholds, alter authorisation routes, or touch surveillance, entry or financial investigation powers. All those sit in primary legislation and remain entirely intact. This statutory instrument simply avoids an unintended enforcement gap following the transition. Members may also have noticed that an earlier version of this instrument was withdrawn. This was to correct a technical drafting point where the original text duplicated a removal of the GLA from Schedule 4 that already occurs automatically under the Primary Act. The corrected instrument before the committee today makes no change to substance or policy. Turning briefly to safeguards, communications data is not the content of calls, texts or emails. It is the who, when and where, not the what. In practice, this means information such as subscriber details, phone numbers, call durations, IP addresses, email logs, and location data from mobile devices, but never the content itself. It can only be acquired by the Fair Work Agency for serious criminal investigations. That means for offences carrying at least 12 months custodial sentence, and only when necessary and proportionate. In practice, the GLAA has used these powers sparingly in some of the most complex and organised exploitation cases, often where victims are too frightened or unable to come forward. Those safeguards carry over in full to the Fair Work Agency. Every application will continue to go through the single point of contact gatekeeping. Routine cases will continue to require authorisation by the Investigatory Powers Commissioner's Office, which will continue to inspect and oversee use of these powers exactly as now. It is worth underlining that the value of these powers lies not in their frequency of use but in their precision. Communications data is a targeted tool that helps investigators build a clearer picture of organised exploitation where victims may be isolated, threatened or unable to speak freely. It allows enforcement bodies to corroborate other intelligence and identify links between offenders and locations. Used properly and under strict oversight, it is a vital element of the wider framework Parliament has already put in place to confront the most serious forms of labour abuse. To illustrate the value of these powers in practice, I can point to a recent case in which communications data played a decisive role. 41 vulnerable workers were brought to the UK with promises of decent work and accommodation, only to be exploited by an organised group. Their wages were taken, false identities created, and they were housed in unsafe and overcrowded conditions. Managers within the employing business even assisted the exploitation by diverting wages and acting as unlicensed gangmasters. Access to communications data enabled investigators to uncover the links between the organisers and those inside the firm, revealing patterns of wage diversion, false accounts, excessive deductions and, crucially, further victims. Faced with that clear evidence, the offenders pleaded guilty and received custodial sentences. On transparency, the Investigatory Powers Commissioner will continue to report annually on the use of these powers, providing Parliament with a clear overview of how these powers are exercised. Additionally, the Fair Work Agency will report on its use of these powers in its annual report. And as we bring 3 enforcement bodies together, the aim is a clearer system for workers and a simpler one for responsible employers. But those who exploit workers, particularly through coercive, abusive or criminal practices, must not be given the opportunity to exploit gaps during transition. So ensuring the continuity of capability from day one of the Fair Work Agency is absolutely essential to that. These regulations provide that continuity. They do so without changing the law on when or how investigatory powers may be used, without broadening the Investigatory Powers Act, and without altering any of the strong safeguards that Parliament has put in place. This is a precise and technical instrument that ensures Parliament's decisions in the Employment Rights Act can operate exactly as intended when the agency becomes fully operational. I commend the regulations to the committee.
The question is that the committee has considered the draft Employment Rights Act 2025 Investigatory Powers, Consequential Amendments and Regulations 2026. I call Dame Harriet Bolt.
Well, thank you very much, Mr. Stewart. It's an absolute honour to serve under your chairmanship this afternoon. And you delivered the title of this legislation with a dryness that belies its actual purpose and its impact on our economy. And the instrument itself looks tiny. There's hardly anything here on this piece of paper. And yet, Mr. Stewart, I am going to argue that this committee should vote against this statutory instrument this afternoon. It may look like a technical mechanism. The Minister described it as a technical mechanism, but what it does is it equips the Fair Work Agency with state-level surveillance tools that were previously reserved for tackling the serious and organised crime that occurs in the gangmaster sector. And it applies those powers, those investigatory powers, across our entire economy. The creation of the Fair Work Agency, a consolidated super regulator with enhanced snooping powers, represents a significant overreach of the state into the private operations of British businesses. And I hope that not only my colleagues, possibly colleagues opposite, but certainly our Liberal Democrat colleagues will vote against this instrument this afternoon, because currently the Gangmaster and Labour Abuse Authority focuses on high-risk industries such as agriculture and fishing, where there have been abuses. But these changes will allow the Fair Work Agency to snoop everywhere, across every workplace in this country. We oppose this statutory instrument as it formalises the transition towards a more litigious, a more monitored labour market, which will inevitably stifle the start-ups, the entrepreneurs, and increase the regulatory burden on small and medium-sized enterprises. It is not a proportionate or a balanced approach to enforcement. We've heard repeatedly from business groups, Mr. Stewart, about the cumulative pressure that they're under. The British Retail Consortium has warned that margins in retail are already at breaking point. The Confederation for British Industry speaks of a chilling effect on hiring as firms brace for more aggressive enforcement. This instrument will give them those powers. And the Federation of Small Businesses has been clear that tighter scrutiny combined with rising employment costs will force many small firms to reduce hours, cut staff, or automate roles entirely, something that we're sadly already seeing in the monthly unemployment statistics. The government claims, the Minister claimed, that the statutory instrument simply ensures continuity following the abolition of the Gangmasters and Labour Abuse Authority. And of course it does, as far as that sector is concerned. But in doing that, it widens it to the entire economy via the Fair Work Agency. It is not, Mr. Stewart, a like-for-like replacement. We are seeing a super regulator with a far wider remit and far stronger powers. And for these reasons, alongside our commitment to repealing the vast majority of the job-destroying Employment Rights Act, are why we will oppose this statutory instrument today, and we urge all honourable members to do so.
Sarah Olney.
Thank you, Chair. I wasn't planning to make a speech, but since Ms Baldwin has said that she plans to vote against this and has invited me to join her in that, I feel I should get some of our remarks on the record on behalf of my party. Just to say that thank you for her kind invitation, but I plan to vote with the government on establishing the Fair Work Agency in line with our party policy throughout the employment rights, the progress of the Employment Rights Bill. We support the setting up of the Fair Work Agency. We think it brings together the powers of several different bodies into one unified place, and I think that is really, really important. I hear what the Honourable Lady is saying about the GLAA powers and that they are being extended. But I think there is a bigger win here in setting up the Fair Work Agency, in that it will not only provide a better route for employees to be able to establish their rights in the workplace, but also for employers, in that if the Fair Work Agency acts in the way that I believe it is intended to, it should relieve the burden of tribunals from employers. Happy to give way.
Mr. Chair, I'm genuinely shocked and surprised to hear the Liberal Democrat line, because I seem to remember when these investigatory powers were first brought in, this right to snoop on communications, their party was vehemently against it, and yet here we are giving these powers to an agency that will cover every job in this land.
I thank the Honourable Lady for her intervention, and I hear what she's saying. I'm just going to repeat what I said about, I think that the setting up of the Fair Work Agency is an important step towards both ensuring that employees can assert their rights in the workplace, and also that employers are not going to be burdened with the undue costs of tribunals. And that is why the Liberal Democrats have supported the setting up of the Fair Work Agency from the start. Happy to give way.
Thank you, Chair. I thank the Honourable Lady for giving way. Businesses in my constituency in Buckingham Regis and Northampton have told me categorically that they are so concerned about this, because entrepreneurs who have taken all the risks to create jobs in their communities run the risk of having the powers to the Fair Work Agency, giving those powers to come into their businesses to really ride roughshod over the work that they are creating. I have to ask you, how is that liberal and how is that democratic?
Well, it's very kind of her to ask me. I would say this is obviously the government's the government's
supporting it.
Statutory instrument, so I'm not entirely certain why I'm getting all the scrutiny here. All I'm going to repeat is that we've supported the setting up of the Fair Work Agency from the very start, and we support the measures in this statutory instrument that go towards that. I hear the Honourable Lady's concerns and the concerns of businesses in Bognor Regis, and obviously the Liberal Democrats are concerned to ensure that any request for information from businesses is done proportionately and only in response to legitimate concerns about employers treating their employees fairly, and that's what we would expect the Fair Work Agency to do. But I'm just going to finish by reiterating that we support the setting up of the Fair Work Agency and this statutory instrument. Thank you.
Minister.
Thank you, Chair, and I thank the Shadow Minister for contributions and the Liberal Democrat spokesperson for their support for the statutory instrument. And it might be helpful for me to just run through the purpose of this particular SI that we are debating today, that I hoped I made clear in my introductory remarks. We'll touch on a few things that the Shadow Minister has raised. So to repeat, we're replacing one specified body with its successor. The Fair Work Agency's remit, as debated throughout Parliament, is established in the Employment Rights Act, which brings together the existing functions of the GLAA, the Employment Agency Standards Inspectorate, and HMRC's National Minimum Wage Enforcement. I think to what the Shadow Minister was alluding to, the Act does include the delegated power to add further labour market enforcement functions in the future, subject to new regulations and parliamentary scrutiny. However, the SI that we're debating today does not use that power and does not add any new enforcement functions. It is purely consequential. So no new powers have been created or previously under the GLAA, which I alluded to in my opening remarks. And the Fair Work Agency will be only able to request using these powers to investigate offences under the GLA's previous remit, and for other offences added to the Fair Work Agency's remit by the Employment Rights Act 2025, as I've said, which we debated. For the sake of detail, the only offences in the FWA's remit that meet the serious crime threshold that I talked about in my opening remarks in the Investigatory Powers Act are as follows, just for clarity. Offences under the Gangmasters Licensing Act 2004 that were part of the GLA's remit, offences under the Modern Slavery Act 2015, again, which were part of the GLA's remit, an offence under Section 1 of the Fraud Act 2006 that was added to the Fair Work Agency's remit by the Employment Rights Act and debated again in the House. The Serious Fraud Office can already request use of these powers to investigate this offence. And the offence of failing to comply with the Labour Market Enforcement Order under Section 139 of the Employment Rights Act, and this supersedes an offence under the Immigration Act 2016, which is in the GLA's remit. The GLAA has never sought use of these powers to investigate the offence in the Immigration Act 2016, and offences under Section 140 and Section 142 of the Employment Rights Act in Scotland only, and these again were considered by the House in committee. So I hope that's clear in terms of what we are actually debating today. The offences to which the power relates to does not change on the remit. We have just transferred over the powers of existing enforcement bodies, but added those extra safeguards. At present, a warrant is not needed to enter a dwelling, for example. So this is pretty clear what this SI we are debating here today will do. And if we just continued as normal, that would actually weaken enforcement, which is not good for businesses. It's not good for those who are the most vulnerable side of the labour market and who need a government on their side to actually make sure that their rights are enforced and they are supported at work to stop, for example, modern slavery. So that's why what we are debating today, is really important. It's really disappointing that the opposition will be voting against that. I thought we'd be on a similar page, because the question here today is whether serious labour exploitation investigations should continue uninterrupted, and when the new agency goes live. So it's pretty simple and technical, as I've alluded to. So it is with regret that the opposition will be voting against today, but I thank the Liberal Democrats for their support, and urge all colleagues to support this really necessary legislation today so we can crack on with enforcement and support the agency to do that.
The question is that the committee has considered the Draft Employment Rights Act 2025, Investigatory Powers, Consequential Amendments, Regulations 2026. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Division.
Division Room 9.
Are the whips happy for us to proceed straight away?
Delighted.
All in a happy place?
Stuart Anderson.
No.
Dame Harriet Baldwin.
No.
Julia Buckley.
Aye.
Nezel Calliscan.
Aye.
Mr. Luke Charters.
Aye.
Kate Dearden.
Aye.
Marcia de Cordova.
Aye.
Sarah Edwards.
Aye.
Daniel Francis.
Aye.
Alison Griffiths.
No.
Gerald Jones.
Aye.
Peter Lamb.
Aye.
Perrin Moon.
Aye.
Sarah Olney.
Aye.
Naz Shah.
Aye.
James Wilde.
No.
The ayes were 12 and the noes 4, so the ayes have it. Unlock. Order, order.
Thank you.